In 1995, the EU Data Protection Directive, the predecessor to the GDPR that came into force in 2018, restricted the transfer of personal data outside of the Union unless the destination country provided essentially equivalent protection for that data and the data subject. It also provided for the EU Commission to engage in negotiations to resolve cases where protection was not deemed essentially equivalent. It also provided for the EU Commission to engage in negotiations to resolve cases where protection was not deemed essentially equivalent. These negotiations led in 2000 to the Safe Harbour scheme for US companies complying with the principles and registering their certification that they met the EU requirements, allowing for the transfer of data from the EU to the US. In 2015, trickling down from a complaint by an Austrian data subject, Max Schrems, the Court of Justice of the European Union annulled the Safe Harbour decision in the so-called Schrems I case, finding that US surveillance laws did not provide adequate protection for personal data. In 2016, the European Commission issued a new decision approving the replacement framework called the Privacy Shield, intending to address prior concerns. Fast forward to 2020, where the Privacy Shield again is invalidated by the European Court of Justice in what is now known as the Schrems II decision, arguing that little had been done to address questions of disproportionate access to data by government authorities and did not provide EU data subjects essentially equivalent levels of legal protection as those available in the EU. On July 10, 2023, the European Commission approved the new EU-US Data Privacy Framework, DPF for short, which now may be used to regulate data transfers between the EU and US companies self-certified on the scheme. Companies that self-certify under the data privacy framework will be able to offer services of transfer or reception of personal data from the EU to the US without any other data transfer mechanism, at least for the companies that are under the framework. This means that companies who are self-certified on this scheme will not need to force clients implementing their services to rely on standard contractual clauses or binding corporate rules to transfer personal data to the US. If the type of data they're certified for, HR or non-HR data, aligns with the data processing needs of the EU implementer of that vendor solution. The Privacy Shield, which despite no longer being recognized by the EU as a usable cross-Atlantic transfer instrument, had been nevertheless maintained in the US for the last 3 years, and companies that were already self-certified under that framework will find it relatively easy to upgrade their participation to DPF standards. Organizations already on the Privacy Shield must update their privacy notices to refer to the EU-US Data Privacy Framework principles within 3 months. Otherwise, as long as a company continues to comply with the principles, the transition is automatic. Organizations must specify whether the data the vendor is certified to handle is HR or non-HR data, as different principles and rules or redress mechanisms apply. EU companies wishing to rely on the data privacy framework as a transfer instrument should check whether the vendor to which they entrust data is self-certified on that list. If it is, check whether the vendor is certified to process HR or non-HR data, or both. If the vendor is on the list but not certified for processing HR data under the DPF, then check whether you are indeed exporting HR data to them. If you are, ensure you rely on another transfer instrument, such as standard contractual clauses. If an organization persistently fails to comply with the principles of the EU-US DPF, it will be removed from the data privacy framework by the Department of Commerce and must return or delete the personal information it receives under the framework. Persistent failure to comply is defined as refusing to comply with a final determination by a privacy self-regulatory, an independent dispute resolution or government body, or frequently failing to comply with the principles to the point where the organization's claim to comply is no longer credible. The Department of Commerce will remove an organization from the list after first providing the organization with a 30 days notice and an opportunity to respond. The data privacy framework has been criticized by the European Data Protection Board and the European Parliament, to name a few organizations, for not going far enough to address the issues of bulk data collection by the US law enforcement authorities. One element of contention being that decisions by the new Data Protection Review Court could retain classified material. Ironically, under the DPF, an advocate is appointed on behalf of the complainant. That advocate can access classified information, while it's argued that this is not the case in EU member state non-judicial redress mechanisms that generally lack a requirement to ensure an appointment of an advocate that enjoys similar clearance to sensitive national security information. That said, with litigation no doubt already initiated, the privacy community expects the DPF to face the same fate as the Safe Harbour framework and the Privacy Shield. Litigators warn that if the European Court of Justice reviewed the data privacy framework, it could suspend it for the duration of the legal proceedings. Now, if the decision is no longer valid, then the data transfers of the companies that are using the framework would be considered unlawful even while the decision-making is in process. A final decision by the European Court of Justice is likely to be made by 2024 or 2025. US companies that were not on the Privacy Shield before it stopped being recognized by the EU Commission should by all means apply to the framework, as it will familiarize them with principles of data protection if they have yet to implement a comprehensive approach to privacy by design. It will also familiarize them with the EU data protection expectations, with the focus on the data subjects, while familiarizing them with the redress mechanisms they will at some point in time likely experience. However, they should continue to honor requests for SCCs and ITAs, international transfer assessments, by EU vendors, as a fair amount of EU mistrust for the DPF is likely to float in the air for the next couple of years. In any case, in light of the well-communicated criticism and upcoming litigations, as much as with hindsight, EU companies should not rush to do away with any supplementary measures implemented to protect personal data. Neither should they rush to convert their SCCs for the glittering promise of a simpler-to-implement transfer instrument. On the bright side, there's no reason to assume that the improvements made to the redress mechanisms during the negotiations of the DPF should not also apply to other transfer instruments such as BCRs and SCCs. And while a lot remains to be seen in practice, and while essential equivalent levels of data protection afforded to data subjects in the EU may still be debatable, this may be the furthest to date we have come to convergence on the rule of law on both sides of the Atlantic as it applies to data. If you have any questions on data protection or need support with your international transfers, get in touch. See you next time.